I don't share those fears because I see it for what it is, which is a tool that creates efficiencies that allows us as humans to be more creative and allows us to do things in ways we weren't able to do them before. I think people share more with the AI because they think no one's watching. Our demand letters, our preservation letters need to no longer ask just for emails. Clients are adopting it just as fast as the lawyers are. The clients expect me to use it now.
Thanks for tuning in to Keep It Legal, the show where we break down concepts, litigation, and current events with our legal experts. I'm your host, Mark Annick. Today's episode focuses on a topic that's quickly reshaping the legal profession, artificial intelligence and its impact on litigation. Joining us today is Chris Schwegmann of Lynn, Hurst and Schwegmann in Dallas. Chris, first of all, thank you for taking the time to join us.
Thank you for having me. Glad to be here.
Give us your bio first. Let's assume that our audience is not familiar maybe with you and your work in the firm. Tell me what you do.
So I'm a trial lawyer based in Dallas. I try all sorts of different cases. I focus mostly on intellectual property cases. Done this for about 25 years.
Okay. And intellectual property, for people who may not be familiar, patents, trademarks, et cetera. That's
right. It's litigation about ideas and ownership of ideas. And often involves different brands, that's when we deal with trademark cases. It deals with copyrights, the written words on the page. It deals with patents, which are ideas that are useful in ways that allow companies to make money and inventors to be successful.
Okay. Do you enjoy being a trial lawyer?
Absolutely. I can't imagine being anything else other than maybe a chef, but that's for a different podcast.
A chef. Yeah, we're going to have to come back for that one.
Right.
We're going to have to come back. We said that we were going to talk about AI, and I wanted to begin with an AI moment that I had and ask you, because I'm guessing you had one as well, because I think we all have had an AI moment within the last several years, right? Mine was a couple of years ago. I don't know if you're familiar with PR Newswire. They send news releases for us sometimes. And I was on a webinar with them. This is maybe 2 years ago. And they were showing us some new tools and toys. And they said towards the end of the webinar, hey, look at this. This is our AI-based platform. And we're going to have Bob, our fake CEO over here, give it some information. And it's going to write a news release for us. And I've been in this business almost 25 years, and the thought of a computer writing a news release was anathema, right? And it wrote a release, and it was
pretty good.
It was pretty good, Chris.
Right.
And I was thinking, well, let me turn in my resignation at the front desk. Have you had, was there any similar moment for you where maybe you didn't see it as job threatening and, we joke, but was there a moment where you went, oh my gosh, that just did something that I never expected?
Yeah, I was aware that these large language models had these tools that could generate text. I was aware of that, and I had read news stories about it. I think what clicked for me, I read a book by Ethan Mollick. He's a professor at Wharton, and it's called Co-Intelligence. And he had some thoughts in the book that really, I guess for the first time, showed me the power of what some of these products can do. And it's not just that it generates text, it's that it generates perspective, and that there's a real creativity to what you can do with it. So you could say, to use your example, I want you to draft a press release, but I want you to do it in the voice of Edward R. Murrow, or I want you to do it in the voice of Walter Cronkite. And so I started playing with the systems using sort of fantastical examples. Like, I want you to do it in the voice of Athena, goddess of wisdom, or I want you to do it in the voice of Sherlock Holmes or someone from fiction. And what came out was so creative, and at least to me, brilliant in showing these different perspectives. It became a tool that became almost like a plaything. And then I said, well, if it can do that, oh my goodness, what else can it do? Can it criticize me? Can it criticize my work? Can it give insight into something in ways that I hadn't thought about before? And so that was kind of my aha moment. It was only after reading that book and then playing with the toys.
You use words like creative and brilliant to describe it just now. On the other side of the equation, people might use words like fearful, problematic. Obviously, you come down on one side of that discussion. Why do you think there is fear out there? Is that just a basic human response to something with which we are unfamiliar?
Yeah, I think a couple of things. I think the obvious fear, and the one that gets reported on most, is that it's going to take all of our jobs. I don't think that's true, and that's something that we can talk about. I can certainly say for lawyers, there's something just uniquely human about being a lawyer and about the judgment that's required of being a lawyer. And I haven't seen a situation yet where an AI can stand in front of a jury and be persuasive in the same way a human can. So I think there's reasons that the most often you hear is that it's going to take our jobs. Maybe the more interesting fear that you hear a lot is that this advent of general artificial intelligence is going to result in the destruction of all civilization as we know it. I don't take that to be a rational fear. However, it's one that a lot of smart people do find rational, that gets reported about in the New York Times and that you hear about from particularly technologists on the West Coast. But I think there's also more of a latent fear that it's not just that it's going to replace our jobs, but that we're sort of outsourcing our judgment. We're not exercising our mental faculties because people are going to use these tools instead of make decisions that we're used to making as humans on a day-to-day basis. I think that's the basis of the fear. It's for me though, I don't share those fears because I see it for what it is, which is a tool that creates efficiencies that allows us as humans to be more creative and allows us to do things in ways we weren't able to do them before.
You mentioned outsourcing judgment, and I think that's a key point. And you don't use AI in your work. You use AI, but you don't use it to outsource. I've read a couple of your writings. You use it to augment?
Yeah, I think augment's the perfect word. I think what you read about or what you hear most in particularly legal literature is lawyers getting sanctioned. Lawyers getting sanctioned.
I have an article about that right here. Go ahead.
You probably have the most up-to-date numbers, but last I checked, it was over 1,000 lawyers or law firms have been sanctioned for hallucinations related to any case law that doesn't exist.
And when you talk about fear, I mean, I'm not the lawyer here. I can only imagine what your face would look like if you were standing before the court and they were saying, Mr. Schwegmann, this case in your filing does not exist.
Yeah, that's right. But you know what's funny about that is since there have been lawyers, there have been mistakes in briefs. And I would have had that case now or then when the judge were to say, well, the citation's wrong or you've misapplied the law that was cited in this case. This is the fact that errors occur in the briefs is something that's happened forever and will happen forever, right? The issue of the hallucinations in briefs, in my view, it comes from the improper use of the tool, right? It's that lawyers who are using these tools to just generate text, right, but aren't applying their judgment to what's been generated. Like that's just not the right use of the tool. And I think as the legal community embraces AI more and more, and we start learning how to use these tools, you're going to see fewer and fewer of these sanction type cases because we know what those tools can do and how they should be adjusted, and the work we need to do as lawyers to apply our judgment to prevent those kinds of errors from happening.
I worked with an attorney last year, and we were in an AI-related discussion. And his rule was you should treat a filing that comes to you that has some AI input as if it's been generated by a first-year associate.
That's exactly right. And that's an example I use too. Look, in the days before AI, a first or second year associate would give me a brief, and I would spend a significant amount of time reading those cases, ensuring the arguments were sound, that they're coherent, right? And the reason I do that is because at the end of the day, the buck stops with me. My name's on the brief. I'm filing it, and I'm the one that has to stand in front of the judge and accept the consequences of what we put together. Why should that change solely because an AI has produced the brief? If anything, we should spend more time checking that what's in there is accurate, coherent, and verifiable.
You mentioned 1,000 sanctions, and I don't know that these are all sanctions, but there is this gentleman in Paris who's keeping track of all of these. You know this website, right?
I do. There's a few folks here keeping track too.
Right, and he's up to 1,667 cases.
Yes, that's the number I saw.
Where people have used AI hallucination cases that don't exist. Many of these are pro se litigants. Many of these are non-lawyers. And I'm guessing they're going to ChatGPT or Claude or what have you, and they're just dropping things into a file.
That's right.
But you're saying, and not to say anything ill about lawyers or the legal profession, that these kinds of mistakes happened in the past. Do you think we're only paying attention to them more because these are related to AI?
I think that, and I think they're happening more frequently now. And it's caused by the fact that these lawyers aren't using the AI correctly. But I think what's unfortunate about the fact that there's so much press about these types of hallucinations, what's unfortunate, it's distracting the legal profession and from practitioners from the benefits that we get from using the AI. So you asked me earlier about fear. I think there are a lot of lawyers who are fearful about using AI because they've seen the 1,067 cases where there's been a sanction, right? And I think that's in some ways stunting them or preventing them from the proper use of these tools, which really can enhance their practice.
You take, along those lines, what I would consider, if you permit the adjective, a professorial approach to all of this.
I don't know if that's a compliment or not.
I use it as a compliment.
Right.
I use it as a compliment because I was fascinated by an awful lot of what you're saying in some of your articles, one of which is entitled Embracing the Hallucinations.
Yeah, that's right.
So we were just talking about how people are fearful of the hallucinations. Talk to me about why on earth would I want to embrace these or welcome them or use them?
Sure. Well, hallucinations are creative in its essence, because what a hallucination is, right, is it's at least in the context of AI, it's something the AI says that doesn't correspond to what exists in the real world, right? It doesn't correspond to the truth, right? But if you think about that in a different context, that's creative. It has created something that is different from what exists, right? I give some examples of creative hallucinations in that article that you referenced, right? So two very famous physicists. I recently read a book. It was in part a biography of these physicists. And what was interesting to me is their best and most creative scientific insight was caused when they were having fever dreams. And of course, they went back and that idea, the kernel of that idea, they then designed experiments around, which changed the face of physics going forward. But it was in the face of a hallucination that they had these insights. So when we talk about AI and when you understand how these AI systems work, literally everything that is generated from an AI system is a hallucination. It's not tethered to the real world. Right. And so the judgment we use as lawyers is if you understand and take as given everything's a hallucination, well, what can I take from that? What creative can I take from that to use in a brief that very much needs to correspond to the real world?
So in that view, then, all of it, rather than looking at the output from the AI and saying, well, that's true, that's valid, you're looking at the output from the AI and you're saying, all of this is just associations.
Correct. It's just words on a page. It's just relationships between words. I think of it as almost a closed universe that's encompassed only with language, right? And I can use that as a sounding board. I can use that as a brainstorming tool. I can use that as a way to think about ideas from different perspectives, right? But what I do as a lawyer is then take those novel, creative, clever ideas, and then I bring them back into my world, the real world I live in, and try to apply those ideas to the facts that exist that I can use in a lawsuit.
Can you go there for me? Because when you and I and our producer, Alyssa Wolf, were talking prior to this, you were giving us some very good examples of how sitting in court or preparing to be seated in court, you were using AI to help with the argument, the rebuttal, whatever it might be that you have to say in a case. Talk to us about the kinds of things you do there.
So I'll give you an example about preparing for an oral argument. So one of the things you can do with these legal AI tools is you can ground the AI with certain facts. So let's say that I'm preparing for a motion for summary judgment argument in federal court. The AI knows, because of its vast training materials, lots of things about the judge, about the venue, about the court, but I can ground it further. I can upload the motion, I can upload the response, the reply, and I can tell the AI, I'm preparing for this argument in front of Judge Lindsay, let's say. I can upload 50 Judge Lindsay opinions that are about the same kind of issue. And then I can ask the AI to, you've now read my briefs, you've now read my opponent's briefs, and I can ask the AI to take the perspective of Judge Lindsay. What concerns you, given what you know? What are the biggest issues you see in my arguments? I can ask the AI to perform a mock argument where the AI pretends it's Judge Lindsay and asks me the questions it thinks Judge Lindsay's going to ask, and I can respond. And the best thing about this is I'll never get to practice an oral argument in front of the real judge, but I can practice 24/7 with the AI judge that I've created based on what it knows from its training materials about this judge, but also what it knows from the opinions that I've uploaded and what it knows about the law in general.
And because it's hallucinating, as you suggest, all the time, it's not afraid to include in that list the question that if I were your first year associate, I'd be afraid to put down on that list.
Yeah, that's right.
Because the fear would be, the court's never going to ask that.
Right.
And that might be the question you need to have in front of you.
No, that's right. And I'll tell you, we've done this with appellate court arguments where for example, the Fifth Circuit, where you have 3 judges asking you questions, and there's so many transcripts involving those judges out there. You can download them from the Fifth Circuit website. If we're preparing for an argument in the Fifth Circuit, we'll go download as many of those transcripts involving those judges as possible. So now we know not just the opinions they write and how they use language to convey certain information. We now know in similar situations the kind of questions that they're prone to ask or tend to ask. So we can then upload our briefs and say, I want to perform a mock appellate argument with these 3 judges. I can either actually do the play acting where they ask the questions and I type the answers, and we can now do it orally with our phones by just asking, but I can also have the AI tell me what are the 5 or 10 questions that Judge Higginbotham's most likely to ask me about this issue. And I'll tell you, it gets it right a good percentage of the time.
That's a level of research. I mean, you've been a lawyer how long now?
25 years.
Okay. That's a level of research that heretofore was unheard of.
Well, what's funny is we used to, before AI, we would do this research.
That would take weeks.
It would
months.
take weeks, and it would take teams of associates with yellow highlighters writing this stuff out. It would take, when we do the mocks, for every oral argument in an appellate court, we do a mock appellate court exercise where we have to conscript 3 or 4 of the other lawyers in our firm to read all the briefs and ask us questions. Now, we still do that in some cases. But now, if I'm getting ready for an appellate argument, I can practice as often as I want at any time of day using resources that are available to me that doesn't involve me bringing in 3 or 4 other lawyers to help.
And you can do that if you get to your hotel room at 1:30 in the morning, right? And you pop open your laptop.
That's right.
In the example that you just gave me, does that lead to fewer jobs for associates, or are you moving those associates to do other things?
I think it's mostly those associates do other things. But, I'll tell you, that's the question that I think I get most often is, what has been the effect of your use of AI in the relationship with the other lawyers in the firm? And I'll tell you, it's completely counterintuitive. And I'll tell you why I say that. In the old days, if I had a brief due on Friday, I'd assign it to an associate on Monday, and that associate would work on it for 2, 3, 4 days, provide it to me on Thursday, and she and I would maybe talk for an hour before it gets filed after I put some edits in it. Now, if I make that same assignment on Monday, I usually, because of the efficiencies caused by the AI, I'll get the brief back much sooner. So how do we use that time? And what's counterintuitive about the AI is I have found that we spend way more human-to-human, face-to-face time than we ever did before.
Really?
Because so we have extra time. And so how do we use that time? We spend more time talking face-to-face about the strategy. We talk more face-to-face about what does the client want. We talk more face-to-face about what are we going to do 3 or 4 moves down the road. Because we're spending less time on grunt work, we have more time to strategize and think. And what surprised me is that we're now spending more time together as humans. And it's funny, I haven't seen that reported on much. I'll tell you, my neighbor upstairs, the lawyer my partner who works next to me is an appellate court partner, and almost all of his work is writing and researching. He has occasional oral arguments, but it's mostly writing. And in the old days before AI, I never saw associates in his office debating, talking face to face, because they were so busy, elbows down, putting work together. Well, now the work gets put together a little bit faster, and I find them now bouncing ideas off each other and sort of cross-pollinating ideas way more than I ever did before. And I attribute it to the efficiencies caused by these AI systems.
You're right. That is completely counterintuitive, the notion that's leading to greater human involvement and interaction. If you play that out, do we wind up at the point where, God forbid, some lawyer does not use AI someday and his client files a claim against him saying that, right, ineffective assistance? Yeah,
it's funny you mentioned that. I just last week saw an article about that, about when are we going to be at the point where it's irresponsible not to use AI. I don't think we're at that point just yet. The Texas just issued an ethical opinion. I say just, it was probably about a year ago, that didn't go that far, but does suggest that lawyers do have a duty to understand these kinds of technological solutions and how they work. But I think you're right. The next step is, do we as lawyers actually have a duty, an affirmative duty, to not just understand how they work, but use them to the benefit of our clients?
I want to shift just slightly. You wrote yet another piece earlier this year for Texas Law Book. The title, "Your Client's ChatGPT Strategy Session Just Became Government Evidence."
Yeah, that's right.
The title alone, I'm sure, sent a chill up the spine of lawyers and litigants everywhere. Talk to me a little bit. This is a case that it's Heppner, right?
Yeah, that's right. United States versus Heppner. It's a case, or the opinion that's discussed in the article was authored by Judge Rakoff in the Southern District of New York. It has a local to Dallas feel because Mr. Heppner is from Dallas. And what happened there is Mr. Heppner knew he was in trouble with the government. He had, on his own, before he hired lawyers, ran a number of ChatGPT queries about his situation. I think he ultimately had 32 chat log that he made on ChatGPT, the consumer version. He got indicted by the government a couple days later, after he had run the searches, before he had hired a lawyer. And the government, the United States, confiscated his computer servers and found the chat logs. Mr. Heppner ultimately hired lawyers. The lawyers said, no, you can't have those questions and answers in ChatGPT because they're privileged and they're protected both by the attorney-client and work product privilege. Judge Rakoff disagreed and said that they were all discoverable. Now, the reason that sent a chill down everyone's spine is because one can only imagine what Mr. Heppner was typing into ChatGPT. It was clearly about his case. And we don't know because those chats are under seal. We haven't been able to see them, but we can imagine what's in them. Am I liable if I did X, Y, and Z? What do I do with the evidence if the government discovers it? Now, I don't know that's what they said, but it's like those kinds of things likely. And that Heppner opinion, it sent chills down, I think, everyone's spine, particularly in corporate America, where the general counsel doesn't always know how the CEO's using these types of tools at home, or doesn't know how various department heads and other folks within the company are using these tools.
But you have to take the view, I would think, if we were in the GC's office, that much like a teacher, right, high school, college, what have you, if I'm teaching a class, I'm assuming everybody's using it.
Oh, yeah.
Right? If I'm in the GC's office, I worry because I'm thinking everybody out there in those cubes, in those offices, they're using it. I'm seeing stuff coming to me. It's a lot more polished than it used to be.
Yeah, that's right.
They're using it.
I'm getting the work product back faster.
A lot faster, as you point out. They're all using it. And so what do you tell? Well, before I get to this question, there's a second case you wrote about called Warner.
Right.
Okay. Talk to us about that. What happened there? Sure.
Warner's it's a case that in some ways is similar to Heppner, but in some ways it's different. So Warner was a case involving a pro se plaintiff, that's a plaintiff not represented by a lawyer, who had an employment law claim against, I believe it's her employer. And that employer sought the same information that the government confiscated in Heppner. So that employer in that case said, I want you, your plaintiff, I want your chat logs and the responses you got from the AI. And that plaintiff said, no, I'm not going to give it to you. It's protected by attorney-client. Well, in her case, it's protected by work product privilege. And in that case, that case had a different result than Heppner. In that case, the judge said, no, I think those chat logs, the prompts and the responses, I think those are protected by work product privilege. And they weren't ordered to be produced there. So you had two cases, and what's ironic is they were decided the same day. You had a judge from New York who said, no attorney-client, no work product. And then you had a judge from Michigan that said, I think it is protected. Now, there are some nuances to both. One case involved the government. One case involved confiscated evidence. The other case involved a pro se litigant. And the scope of work product privilege is a little bit different with respect to both. But it was different results on the same day, and it caused quite a stir in the legal community.
By definition, and again, you know this better than I do, that feels like an appellate case that's coming at some point.
Yeah, I think so. I will tell you that the opinions that have issued since are sort of coalescing around the Warner result. So there's a case in Colorado called Morgan that also involved a pro se plaintiff, and the result was consistent with Warner. And then, interestingly, in Texas, the Texas Business Court just issued an opinion involving the same subject matter, and it also adopted or suggested approval of the Warner in the Morgan rule, rejecting Rakoff's ruling in Heppner.
So given all of that, and given I've been taught by attorneys that the law runs years behind the technology, if not decades, right?
I think that's right.
But you've got clients today, and you need to advise them today as to how they should be using this technology that, by your own statements, you find very creative and sometimes brilliant in the things that it will suggest. So what do you tell your clients to do given these cases that are out there and these issues?
Yeah, so I've spent a fair bit of time over the last 4 months visiting in-house legal departments at different clients. And there's always, the discussion always centers around two big picture issues. One is, how do you use it? What are you using it for, and how can I benefit from those efficiencies? And when I have that discussion, we talk about use cases, we talk about responsible use cases, we talk about ways those companies can get some of the benefits that I've enjoyed. The second basket of conversations we have focuses directly on Hepner, Warner, and Morgan, and oh my God, what am I going to do when I get my first discovery request asking for my CEO's chat logs, right? And that's a discussion that's much more legal and prescriptive, and we talk about AI policies, and we talk about technological solutions, and we talk about guardrails that you can put in training for your executives.
On the other side of that, though, you are sometimes on the plaintiff's side on behalf of some of your clients,
Sure.
right? I would think that just like emails and texts, and it is in one of your articles,
Yeah.
this needs to be on your discovery request.
Yeah, I think this is, in light of the Hepner opinion and what's emerging with Warner and these other cases, it really requires us to rethink our standard playbook as plaintiffs' lawyers when we're acting as plaintiffs' lawyers. Our demand letters, our preservation letters need to no longer ask just for emails. We need to ask that defendants preserve exactly this sort of information, the chat logs, the responses to that. You know, when we send discovery, when we send that first set of interrogatories, we need to think about allocating at least one interrogatory to, hey, what AI systems do you use? How are they used? Who uses them? What policies do you, if you're a company, have in place with respect to those different logs? But it's clear that this is a tremendously rich source of evidence that right now not many lawyers are mining.
Talk to me about, compare and contrast, if you would. I worked with a family law attorney years ago who, you know, you're working with divorce cases and people who are alleging affairs, et cetera. And she said, you know, text messages, just gold for
Sure.
her, right? Because people send a text
That's
and they
right.
think, oh, no, it's between me and her. And
Right.
well, it's not anymore, right? How do AI platforms and the information that you derive from them, how do they compare in terms of their value if you're on the plaintiff's
Sure.
side?
I think it's just an incredibly rich source of data. And I think I think there's some reasons for that. There's you know, now in 2026, even non-lawyers know they can get my emails. And I think today, even non-lawyers know the lawyers are going to get my text messages. I don't think, and so people are more guarded about what they say in writing. And I think the level of information that people are now putting into AI, I don't think people are thinking about it in terms of discoverability and in terms of how it can be used. I'll give you an example. My wife showed me this meme she saw on her phone, and it was a wife talking to her husband, and it said, the wife says, "Let me see your emails," and the husband says, "Okay." And then it says, "Let me see your text," and the husband says, "Okay." And then she says, "Let me see your chat logs on ChatGPT," and there's this image of him making this face like, "Oh my God, anything but that." And I think that's true. I think people share more with the AI because they think no one's watching. They think it almost as a confessional. They think of it almost as a therapist, help me solve a particular problem. And when people are unguarded in that way, they reveal quite a lot.
Well, and you see those stories where you mention a therapist or a confessional, you know, a priest in the form of a computer. You've heard of those cases where people develop a relationship with something that the algorithm has created.
Yeah, it's true. It's true. And you know, I have some sympathy for those folks. I see how that happens. We have this tendency to anthropomorphize our technology. And we've always done that, but it's even more, you're even more susceptible to do that with these AI systems because they seem to have a mind. They seem to interact in a way that no other technology before has.
They tell you that they're going to flatter you.
Yeah.
And yet every time they come back and they'll tell you, Chris, that's a really good question.
That's right.
Do you do like I do? Do you go, wow, I must really be smart?
Yeah, you know, it's funny when you find, I always find when I find myself nodding in agreement or if I feel a sense of relief that it agreed with me, that's when I know I'm not being objective. That's when I know I'm being persuaded, right? That's when I know I need to push back. That's when I know I need to use my skills as a litigator to cross-examine the AI because I'm not using it because I want it to tell me what I want to hear. I'm using it to challenge me, to make me think of something new. And so I will often, when I get a response that I like, I'll say, let's pressure test that. What would my opponent say about that? Now I want you to be my opponent, and I want you to be really mean to me and tell me how all of my ideas are terrible and explain to me in step-by-step fashion why. Because that's what I want. I want the criticism because it's the resistance that creates growth, right? It's the resistance that creates something new.
It's like having a coach, right?
Correct.
Who's pushing you beyond what you think you're capable of doing.
That's right.
Can you go a little deeper into that? In one of your articles, you talk about, you mentioned Judge Lindsay and getting ready for an argument and all of that. But you also sit in court and you ask chat or you use Harvey, I think you said.
That's right. We use Harvey.
You ask it, well, here's my argument. What's the other side going to bring to oppose that? And you ask that in multiple forms.
Oh, that's right. I mean, we will do that before a hearing. We will do that before a trial. We will do that sometimes in court. If I hear something unexpected, that if we have time to prepare, we can raise those during the actual proceedings and point us in the right direction for where we might find the documents or evidence to refute something. It's just an incredibly useful tool to have with you.
You like to think and you like to write, I can tell, reading these articles. This is a technology and the implications of which are changing regularly. But I want to ask, where do you think we'll be a year, 2 years, 5 years, specifically in terms of how you and the legal profession will be using the technology?
It's amazing to me how quickly the legal industry has gone from almost no adoption to the adoption rates that we've seen now. I think I read an article the other day that said something like 87% of lawyers are now using AI in some form or fashion. I don't know how they came up with those numbers and what they mean when they define AI, but that's just a tremendously fast adoption rate. I think in 5 years from now, almost all lawyers will be using AI in some form or fashion. What's interesting to me about that too is even 2 years ago, I had my own partners telling me, why are you using that? Why are you saving time? You're taking away, you're doing things so fast that you're not billing the amount of time that you could bill if you weren't using the AI. And my answer was because, although I may not be getting the immediate benefit of those billables, right? What I'm getting clients for life, clients that so appreciate the efficiency and know that I can be that efficient that I'm getting they'll call back every time they have a problem. And I'll tell you the other thing about to be more responsive to your question about where are we going. Part of the reason I think that almost all lawyers will be using AI is because I think almost all clients will be using AI. And the clients are adopting it just as fast as the lawyers are. The clients expect me to use it now. 3-4 years ago, we would have client outside counsel guidelines that say, we don't want you using AI. Now I have to respond to RFPs that say, tell me how you're using AI, because that's going to go into the decision about whether we hire you.
Do you think, in terms of your approach to this, you're the exception or the rule, or somewhere in the middle?
I think that's a great question. I think I'm probably on the outer. I think I probably use it as much as anybody. I think I would characterize myself and maybe a handful of others in the firm as power users of AI. When I say power users, though, I don't mean because we use it to generate text that gets filed. I think power users in the way we use it to help engage our thinking, right? I think we're using it in more unique ways than I think the average lawyer's probably using.
Do you see a course coming in law school that helps law school students figure out how to best use AI in the thoughtful, creative manner that you're doing?
Yeah, it's already here. My wife's a law professor at SMU Law, and she was telling me just recently the legal writing department at SMU has started providing a course on the responsible, safe, effective, and creative use of AI. You know, it's interesting, though, not all schools are the same. University of Berkeley banned, or Berkeley Law School banned all student use of AI, which no one's asking me, but I think that's exactly the wrong decision. Kind of goes back to what you said before. Those kids are using it, and they're going to continue to using it. And let me tell you something else. When they graduate from law school and come to work at the law firms are going to expect they know how to use it. So putting your head in the sand and banning the use just strikes me as a wrong-headed decision.
Chris, we could probably go on talking for a while. Perhaps we'll come back and chat about AI again as it evolves.
Sounds good. Thank you for having me.
Thank you for taking the time. I appreciate it. Once again, that was Chris Schwegmann, we should mention, managing partner of Lynn, Pinker, Hurst, and Schwegmann in Dallas. You can visit lynnpinker.com for more information about the firm. That's lynnpinker.com. Make sure to like us on Facebook, subscribe to us on YouTube, and tune in next time to Keep It Legal. I'm your host, Mark Annick. We'll see you then.